This is TLV1.
The Tel Aviv Review.
Hello and welcome to the Tel Aviv Review, where we talk every week about books and research and other things that have caught our attention. I'm your host, Gilad Halpern.
And I'm your co-hostess, Dalia Shenlin. Now, before we start, we want to introduce a very cool new feature. Our guests and topics often spark interesting discussions online, but these discussions are scattered on Facebook, Twitter, emails. We get personal emails. We want to encourage discussion on each episode in one place. So we're creating a special Patreon post for each episode where you can ask follow-up questions or discuss the topics further with other listeners. We will link to the post directly in each episode's show notes so that it's easy to reach. Just go to your podcast app, find the show notes, click on the link, and it will take you to the post. Gilad and I will review the comments, and if you write really interesting questions and comments, we will discuss them in the next episode. You don't have to be a supporter of the show to join the discussion, although we definitely encourage that. Just go to patreon.com/Tel Aviv Review or find the link within each episode's show notes. This episode is brought to you by the Israel Democracy Institute, and it's part of a special series of podcasts in partnership with the Institute. Earlier this year, we focused on the Israeli elections in April, but now, what do you know? We're focused on the September elections. Apparently, we like them so much that we're doing them again. And we're very pleased to welcome Dr. Amir Fuchs. He's the head of Defending Democratic Values Project at the Israel Democracy Institute. Dr. Fuchs holds a doctorate from the Faculty of Law at Hebrew University of Jerusalem, and he's a lecturer in the Politics and Communication Department at the School of Government and Social Sciences at Hadassah Academic College. He's an expert in democratic values and anti-democratic legislation, criminal law, liberal thought, legislative processes, basically everything you need to know. Amir Fuchs, welcome to the show.
Hi, how are you?
Good. I want to start with an article that you wrote in January when you argued that what was the outgoing Knesset, the 20th Knesset, in Israel's history, was the most damaging with relation to democratic values, freedom of expression, gatekeeping, and above all, minority rights. Even more damaging than the infamous 18th Knesset from 2009 to 2013. And that Knesset brought us some pretty anti-democratic laws like anti-boycott law, the anti-Nakba law, admissions committees that allow residential discrimination, and others. What have you got against the 20th Knesset?
Most of all, I think the biggest problem with the 20th Knesset was the nation-state law. The nation-state, the basic law, Israel is the nation-state of the Jewish people, which is maybe more damaging than anything, than all the other legislations that passed. We have some more damaging issues that didn't pass, for example, the override clause, which was close to passing the 20th Knesset, but the nation-state law really changed the whole atmosphere. Even today, when I came here, you heard about what happens in Afula and about keeping Afula Jewish. There's a dispute about Arabs trying to buy homes in Afula. And of course, that's another article I wrote about. I said, in a way, why can we have any complaints for Afula? If Israel defined itself as only the land for Jews, with no respect for minorities, no mentioning of equality, why are you expecting Afula to do anything otherwise? And in that way, I think the nation-state law is the most damaging. I think, and I hope, that the Supreme Court will interpret it very narrowly and maybe will took the stain out of it.
What do you think could be the practical implications of the
because a lot of people
law?
say, it's just symbolic. What is it? I've been asked many times, what does it really change?
Yeah. First, there are some articles within this law that certainly can change. For example, about the language. It changes the definition of the Arabic language from a formal language to a special language. Of course, they say, well, it wouldn't change anything. But it does mean that it can block changing for the better, to give more appreciation for the Arabic language. But the most problematic issue there is the attempt to change the balance between Israel as a Jewish state and as a democratic state, and the fact that the Supreme Court from 1995, 1997 interpreted the basic law of human dignity as including equality. And we don't have equality anywhere in our basic laws, only in the interpretation of the court. And of course, the idea of the nation-state law was to change this. And I can hope that the court will block this and say, well, there is no contradiction between the old basic law and the new basic law. Maybe it will not change. But the big problem here is maybe not in the practical, because basic laws are our quasi-constitution. And constitution has a very important issue of message and of education and of symbols. And symbols have meanings. And when I think of my children, when they will have on their wall, and I'm sure that the basic law nation state will be on the wall, if it's not already on the walls of classrooms, they read the definition of Israel. This is like the preamble for our constitution. And this definition does not include any equality and any recognition of rights for minorities. This is a very, very problematic message. And it sends a message that gives us almost like two classes of citizens, although I think that in the practice it will not happen. The Supreme Court will prevent it as long as it will be strong like today. But when you look at the message and the educational message, it's disaster.
I just want to acknowledge that both Gilad and I have lots of questions, and he is graciously allowing me to ask the first one because this is a burning question for me. I want to talk about this issue of equality. You wrote that there is no country in the world that has not specifically enumerated the right of equality in its constitution. Now, in Israel, I hear lots of learned people debating this issue. Does Israel have any legal guarantee for general equality of all citizens in its laws or in its basic laws?
No. It has only the Declaration of Independence that does say that, but the Declaration of Independence is not a legal, formal document. The Supreme Court is this institution that gives us the equality because the Supreme Court interprets the word human dignity in our basic law, freedom and human dignity, as including equality. But as long as you might change the power of the Supreme Court, or if you changed the people in the Supreme Court in the way they are appointed, or just by appointing people who will change this interpretation, then you have no stability and no legal and firm basis for saying that Israel has equality for all its citizens. And especially after the nation-state law, this is undermined. It's not... We don't have any insurance for that.
But that is really a legal conundrum when it comes to the interpretation of the law. When you look at the Jewish and democratic state, I mean, a lot has been written about the inherent contradiction between the two. There is some friction. I mean, there are ways to harmonize the two, but there's always some friction. What do you say to people actually from the maybe Arab citizens of Israel who say, what's the difference? I mean, this is what it does. It enshrines a 71-year-old reality that we've experienced for so many years. I mean, there is no equality as long as the state is Jewish in any kind of constitution.
Well, I don't agree. And I think that the contradiction between Israel as a Jewish nation state and as a democracy is not a necessary contradiction. I truly agree that there is some tension. There is tension, but it's not necessarily a contradiction. If you read the Declaration of Independence, that say on one hand that this is a nation state, and on the other hand that you will give full equality for your citizens, then you see that you can reconcile between the two. And for example, the law of return. Everybody say, well, this is a racist law. It's only Jews can come and be citizens of the state. But there is no discrimination between the citizens. This is discrimination between the people of the world. And when you look at other states, when you look at laws that define who can come and become citizens, they are not equal, and especially when it's nation states. So Israel did not invent the issue of nation state. There are other nation states, some of them even ethnic nation states, just like Israel. But in all of them, and we studied all the nation states and all the states, all the constitutions, but especially in the nation states of a specific people, like Hungary, like Serbia, like Croatia, you see there in the preamble, not just a statement about equality. That this is for granted. In every constitution you see equality before the law, but specifically you see that this is the land of all the citizens. Or even in the new Orban Hungary constitution, it says that all the minority are part from the state. And this is what is different. This is what is lacking in our nation state. This is the only nation state that actually excludes the minorities.
Okay, so I want to pick up on a word that you said it several times, and that is constitution. You said you studied other constitutions in the constitutions of other countries. Israel famously does not have a constitution. Or a formal constitution. To what extent do you think this is really the original sin? The first Knesset's failure to pass a constitution. I mean, I'm assuming that it would have made things a lot better 71 years down the line. Do you agree? Or,
yes.
Could we have had it different without a constitution?
Yes, surely. And what you said, I totally agree. This is the original sin. And this is why, and if we put aside for a minute the nation-state law, this is why we are afraid from what will happen in this future. Because any majority of a 61 vote can change everything, can change the method of election, can change the powers of Supreme Court and all the checks and balances that, by the way, we almost don't have any checks and balances in our systems because, for example, we don't have two houses in the parliament, we don't have a veto of a president, we don't have almost any inspection from the parliament on the government. The only check and balance that we have is the Supreme Court, and the 61 majority can change all that in 3 readings in 1 day. And this is because we don't have a formal constitution, which is basically, when you have a formal constitution, you have some kind of, you have a special majority to change it, like in the United States, which is impossible almost to change. But in other places, it's not impossible, but it is hard. You need to have 2/3, you need to have a referendum, you need to have in 2 houses or in a lot of specific states in a federation. Here, you just have to get a 61 vote, which every coalition has a 61
So
vote.
in other words, these basic laws are not actually any harder to overturn than a regular law unless it's specified in that specific law.
Yes, and sometimes it is specified that you have to have a majority of 61. That's it.
That's
There
it,
is
which is
no
just
bigger
half plus
majority.
1. It's 50% plus 1.
And most of the basic laws are not even entrenched in 61. For example, a pretty important one about the human dignity and freedom is not entrenched at all. You can change it with a vote of 2 against 1, 3 readings in the same day. This is our constitution. And
So that
I
one only
agree
needs-
that it is not a real constitution. It is a quasi-constitution that the Supreme Court interpret as a constitution, but it is not a constitution in a formal way that it is hard to amend.
I just want to make sure we all understand, because these procedural elements become very important in the public debate when people talk about the basic laws as a stand-in for a constitution. But what actual status do they have? So the basic law that you've been referring to is the law on human dignity and freedom. And it is the only law that has been passed and interpreted as guaranteeing something like equal rights, even though it never says the word equality. I know because I've done a word
Something
search.
like a Bill of Rights. It's not just equality. It's a lot
But
of
it
other
does not
rights.
say that, right?
It says some of the rights,
But it
like
doesn't
the
say
right
equality.
for human.
It doesn't say the
say
word
equality.
equality.
It doesn't say
Right.
freedom of speech.
But that's the one
yeah.
thing that's the one law that's interpreted that way by the Supreme Court.
Yeah.
And you're saying it can be overturned by a simple majority? In other words, not even, a majority, not even 50 plus 1, a majority of all those present that day?
Yeah.
So why are they going for the override clause that we're going to get to now, and not just scrapping the basic law on human
Because there is still human dignity and
human
freedom.
dignity and freedom?
Yeah, because I guess there is still, they know that there will be a political price, a public price to say, well, we're abolishing our basic rights, and they don't want to admit it. So this is why they say we will still have all our rights. No, we're not saying that Israel has no rights, and we have to say it. We say it to the world. We say we have equality, we have human dignity. They don't want to admit it. And this is why when people are talking about why an override at all, because you can always amend the constitution. The only place that has a real override is Canada. And you can say, well, you can change the constitution. But this is how you keep the constitution and still override it.
Have your cake and eat it too.
Yeah, you say, well, I don't want to change our rights. And it's just that I don't agree with the verdict of the court. This is why the court strike down a specific law, and I will reenact it because I don't agree with them. This law does not really infringe in an unproportional way.
That's what the override clause means.
Yeah, this is what it means for the people who try to enact it. Yeah.
Tell us also about the immunity law. The immunity law famously was one of the main principles of this stillborn coalition that did not get formed, but it's following the April elections, and it seems like that the prime minister was originally hoping that there would be some immunity law passed. What were they debating? What were they proposing? And apparently, this was a law that was in place up until 2005.
Yeah.
So some people say, well, Israel was just fine before. Why
Yeah.
can't we have that immunity back? Tell us what it is.
This
and
needs
the
some
story.
explanation, yeah, because we did have this law that they want to reenact until 2005, which said that if the Attorney General wants to indict, he has to go to Knesset and ask for the removal of the immunity. So the default is that there is immunity. And in 2005, after several cases that Knesset revoked the immunity, and they had no real basis for not revoking it. And the Supreme Court, in a lot of decisions, said that you can not revoke an immunity only if you have some grounds, some basis to say that the Attorney General is just persecuting someone. Because the whole idea is not you will defend me, I will defend you, and some haven for criminals. The idea of immunity is to block persecution without any evidence by the government and with the police against the legislature.
So it sounds there's lots of checks and balances in Israel for protecting potentially corrupt legislators.
Yeah. The only check and balance there is, again, the review by the court that says, well, you have no real ground, and then we will revoke the immunity. So after a few shams like that, it was really embarrassing. There was understanding that we should change the law, and the law changed, and not in such a dramatic way. It changed that the default is changed. Now, they can get immunity only if they come to the Knesset, if the MK, when he knows, and the Attorney General announces that he is about to indict,
or she.
Then, they come to the Knesset and say, we want immunity. And it's the same majority. They have to have a majority within the committee of the Knesset, and after that in the plenum. But it changes maybe the politics when you ask for it, or after the difference is this is the default, and maybe we don't want to take away the immunity. It might be easier for Netanyahu to get the immunity with the new law. This is one they want to change, but I don't think it is that dramatic. I agree that this wasn't the really important law, and this is why from the beginning they actually said, well, we don't really need it. We can just use the current law. The more important change is that they wanted to take away the court to review the decision about the immunity.
Which is the override clause.
No, it's not the override clause, and I want to correct
lots of misperceptions.
Yeah, a misperception. This is not an override clause. The override clause is always about when the Supreme Court strikes down a law and you can reenact the law. Or there is another version of the override clause that you, from the beginning, enact a law and said this law cannot be struck down by a specific basic law. So the override is whether an override over the decision of the law, the court, about a specific law, or an override over the basic law, or in Canada, override over the Constitution. This is the override. This is not an override. What they wanted to change is to take away the authority of the court to have review over this kind
Cancel judicial review in general?
No, cancel some parts of the judicial review. This was only in talks, so we didn't really see the bill, but we saw bills from the former Knesset, which was actually basically the same. The bill says judicial review over decisions, not over the law, not striking down law, over decision of the administration. The court cannot give decision over the decision of the government or decision of the Knesset or decision of the president.
What they call administrative decisions.
Yeah, this is so they don't totally abolish administrative review, because administrative review is all over the officers of lots of parts of the administration, not just the ministers. But when you take away the power of administrative review because you want to change the review over the decision of the Knesset regarding the immunity, you actually take away the most important part, as I see it, of our Constitution and over the Supreme Court. Because this is not after the revolution of 1995. This is from 1948. And this is in every country. In Britain, which don't have a constitution, in every country there is administrative review that looks whether the government and the ministers are acting according to the law. And the review about the Knesset here is whether they are acting within their authority of the law of the immunity.
Okay, well, this raises, I think, two very critical questions. I'm going to start with one, and then we'll see how far we get. These are of equal importance, so I'm not asking them in the order of importance. But is there any doubt that the laws they were apparently negotiating over in the previous coalition negotiations, the immunity and the override, was there any doubt that they were developed?
Override and the taking away of the
canceling
powers of
the right
court.
of judicial review and administrative
review.
review.
Basic law judiciary.
Okay. Is there any doubt that they were developed personally to protect the prime minister?
No.
No doubt.
I have to say two things. First, of course, that there was a motivation that comes from the will to protect the prime minister. It is very, very clear. Nobody even said in all the years from 2005 that there is a problem with the immunity law. Nobody said it. And nobody thinks that there is a problem there. So it is very clearly that this is personal law. I agree that the law that about the override about laws and the law that takes away the power of the court for administrative review, there are supporters for that regarding the issue of the prime minister, because they don't want review. They won't want any checks and balances. And maybe we have to say something that we didn't say, that where is this all coming from? We talked from the beginning about anti-democratic legislation, and there is clear ideology behind it that is not personal. And the ideology is rule of the majority. So any checks and balances, Supreme Court review, Constitution, they tried to take away or to minimize the authority of the state comptroller. There is a lot of, you see about the media, you see about the academia, everything that is not from the people. And this is not just in Israel. This is, a trend about us, the people, and them, the opposition. So there is ideology behind the idea that you should take away the powers of the court, regardless of Netanyahu, because they really want to take away the powers of the court. I don't say that everyone in the coalition thinks that you have to take all the powers of the court, and maybe some of the persuasion there is personal, but there is a big, strong ideology that said we should take away most of the powers of the court or some of the powers of the court because there is an imbalance. They cannot rule. The majority cannot rule. Yeah.
It seems like if these efforts become successful, it will unleash such a huge constitutional overhaul and even constitutional crisis. I mean, in the fact that, Israel, once these clauses are passed, these amendments to the laws are passed, Israel will no longer be the same country that we know now. Don't you think that there'd be like a backlash from the judiciary? It will make them redundant almost entirely. How will that affect? It seems to me like very unlikely that, these laws are passed in 3 readings on one day, as you said, and then the next day Israel will be a completely different country. Do you think that this is like going to happen that way? How will it come about?
I really can't tell if some of these suggestions were like, I'm not sure how to translate it. In Hebrew, we
trial
say
balloons.
izim.
Oh, right.
Yeah, trial
balloons.
To try to send message and then to compromise only on the real override, for example, or only on some of the issues, and then get maybe on the next Knesset, and then come
little
forward
by little,
with it. Yeah,
incrementally.
and incremental change. Because you don't want to show to the people that you are actually having a revolution in the powers of the court. Yeah, that's one thing. So I'm not sure they really wanted to pass everything like they wanted. But I was afraid that they will, because the whole issue was the immunity of Netanyahu, and they did have to change the law of the powers of the court in order to secure this issue of the immunity. So this is one thing. And I agree with you that it will put us in, if all of this would have passed, it would put us in a very serious crisis, an constitutional crisis. For example, Aaron Barak said that if he was a justice in the Supreme Court under these laws, he would just resign.
The former Chief Justice who was credited with the judicial revolution.
I actually agree with him. If you're in the Supreme Court and you have no authority, there is override over the constitutional verdicts, and there is most of the authority over administrative law is taken away. Well, Yariv Levin, you be the Chief Justice yourself. I totally agree. Another path that might have happened if the Supreme Court had a lot of confidence, I'm not sure this is the situation, they might invoke what we call unconstitutional constitutional amendment. You might have heard it.
Not really, actually. You're scooping us. Come on.
It exists in the Israeli law?
There is this theory, and some of the verdicts of the Supreme Court are implying that they might do it in a very extreme situation, that the Supreme Court will actually say that a basic law is unconstitutional. A lot of people, my son, who is 11 years old, asked me, well, if the Knesset will pass a law that says that the Supreme Court cannot strike down laws, can't they just strike down this law? This is a good question.
You can see what career he's headed for.
Yeah. A lot of people ask that. Well, what's the issue? They can just strike down this law and everything is okay, but they don't have the power, at least until now. They never done it, to strike down a basic law. This is the change. And the rule of the law of override and all that are changes to the basic law. So then comes the question, can they say a basic law is unconstitutional? And again, we didn't invent this question. It happened in other states. There's an important and a good friend of mine, Yaniv Roznai, you might have heard his name, and he's recently researching this, and he published books about this, whether the Constitutional Court has power to say that the constitutional amendment is unconstitutional. And there are a lot of issues about, we don't have the time for that. But of course, it might happen. And this is why there is, for example, a petition on the nation-state law. People say the Supreme Court should abolish this nation-state law because it's against equality and against our democratic values. I'm sure that the court will not strike down the nation-state law. It will interpret it maybe narrowly. And this is what they will do whenever they have the power not to strike down a basic law. But maybe, and this is why you ask about constitutional crisis, maybe if they will say, well, the override or the taking away the powers of administrative review, this is goes against the core values of the state, against the core values of democracy, and that's why we abolish the basic law. And then will happen the question that we all debated about after our new Minister of Justice interview, which says you don't always have to respect the verdicts. And then this will be the real test. Will the government and the Knesset respect a verdict, a very active and revolutionary verdict that says a basic law is unconstitutional? And if they don't respect it, then we're really in a state that the police will have to decide whether to obey the government or obey the court. This will be a big constitutional.
Just to clarify for our listeners that the newly appointed interim Justice Minister Amir Ohana said that maybe the state doesn't have to implement all of the verdicts of the Supreme Court, which caused this great big debate.
Yeah.
Amir, I want to go back to something you talked about before when I asked about whether this was definitely personal, the attempts to pass these laws. And you said, well, mostly, but there is also an ideology behind it. Now, to many of us who cherish democratic institutions, all of these things seem very, frightening and awful. But for many Israelis, it is simply true that the court has gone too far. They feel that the Supreme Court is a dictatorship that interferes in fields well beyond their jurisdiction. One of the main claims that I hear from people who feel this way, which is largely on the right wing, is that the court actively endangers Israeli security. You can read this every day in the newspapers, and that it has far overreached the intention of the Constitutional Revolution of 1992, and that it is relentlessly activist. And so the idea of canceling the right of administrative review is because people say, well, maybe the court hasn't struck down so many actual laws, but it is constantly striking down administrative decisions. The government can't function. The government represents the will of the majority, and the court is like a chokehold. Why do they feel this way? Why do you, I assume, disagree?
Yeah, well, I disagree, and I agree that this is, as I said, this is an ideology. And we have for years people in the government and in the Knesset that try to persuade people that this is the situation.
And successfully.
And, yeah, they have some success. But I must say that at least according to our polls, until now, there is still a majority that supports the court. And there's still, when you really ask the question, for example, should the Knesset have the right to reenact a law that was struck down by the Supreme Court? There is still a small majority that is against that. So it's not like they want to show us that we, and I say we, me and other people that support the authority of the court, are like a very small majority. There is you can put all of you in a small cell of 5 people. No, there is still a majority that supports the Supreme Court.
Even though I know the polls and they have been declining ever since historically the Democracy Institute started testing.
That is why I agree that the propaganda is successful. I agree. But it's not like they say we represent the vast majority of people who are against the Supreme Court and we are the people. It's not true.
But you're claiming it's propaganda. Yeah. You don't think there's any truth to it.
Yes. Now I come to the substance. So in the substance, you can always argue about specific verdicts, which I can agree that sometimes were wrong or were too active. This is specific cases. But when you look at the big picture, first of all, about striking down laws, it happened from 1995 18 times. 18 times. People are have a thing that it happens every week or every month. It doesn't happen so often. And also when you look at administrative decisions, then there can be dispute about how you measure it. So I won't get into the details, but it is really rarely happens that the Supreme Court intervenes with an administrative decision of the government or specific ministers, only if they're outside their authority. But, for example, you mentioned security. Well, About security, it's almost absurd to say that the Supreme Court is very active. It is quite the contrary. We're almost the only democracy that you can say there is targeted killing that the Supreme Court allowed. And there is administrative detention, which is very
undemocratic.
It's not rare. We use it often.
All the time.
We have a deportation, that the famous verdict of Barak and Shamgar of the Hamas deportation to Lebanon.
Aaron Barak, the one who is accused of
and Aaron Barak
revolution.
also allowed for special measures in interrogations which are actually close to torture. Yeah, we can debate. I don't agree that it is torture. Some people say that it is torture, but it doesn't matter. The Supreme Court actually allowed in specific cases. We have a lot of decisions of the Supreme Court. It is a series of decisions about demolition of houses. The Supreme Court almost never said to the government, I disallow this measure of fighting terrorism. It is totally the contrary. It always said that it's okay. For example, about a year ago, there was a very important decision. Can we have snipers that shoot the people who incite on the other side of the fence against the Gaza in the Fridays riots? And the Supreme Court allowed it. The Supreme Court almost always, he's put some boundaries, but he never said, you cannot do that. So it's actually on the contrary. You can say that it might be a little bit active, for example, issue of religion and state, about the enlistment of the mega Orthodox. This is a place that the Supreme Court was active, or the issues of the asylum seekers. But around security, not at all.
The outgoing, she's already a former Justice Minister, Ayelet Shaked, who was famous for adhering to that ideology of minimizing the scope of a judicial review. It was famous, among many other things, for appointing so-called conservative judges to the Supreme Court. Do you think that, maybe it's too soon to judge, but do you think that their presence there on the bench of the Supreme Court, debating all these issues, have changed or are likely to change any sort of the debate that we've been having now?
Yes, we can see specific sayings by some of the new judges that surely shows a more conservative. And, for example, they see the reasonableness ground as a lot narrower. And I say it's totally legitimate. And when you think about when the government says we have no powers, you did appoint some justices for the court. And this is some of your powers. You can change the laws, you can change the basic laws, and you can intervene with appointment of judges. So this is a legitimate way that the government and the Knesset can try to limit not the authority of the court, but limit, for example, the activeness of the court. So
do you think that before that, there was some truth in the claim that the Supreme Court justices were too like-minded?
And too liberal?
I cannot say that they were too like-minded or too liberal, because since 2003 or 4, I'm not sure exactly on the year, we had an amendment which was important to the way we appoint judges. And maybe I have to say a few words about it if we have time.
Very quickly, yeah. Because we have two more questions that we have to ask.
On contrary of what people say, that the judges appoint themselves or something like that, which is, of course, absurd to say when the Minister of Justice can say that I appointed judges, then how can one thing contradicts the other? Then we have 9 people in this committee. 3 of them are judges. 4 of them are politicians, and sometimes 4 of them are totally from the coalition, although it contradicts some agreement, but it actually, sometimes you have 2 members of the coalition and 2 members from the government, and you have 2 members from the bar. This is the 9 people. And in the past, you only had to have a majority of 5 to appoint a justice to the Supreme Court. So sometimes the justices, if they had good relations with the bar, they can just appoint with 5 people. But this is also not accurate, because the chairman of the committee is the Minister of Justice. So they have a lot of power whether to have a hearing or not. So if they didn't have some kind of the nominations, then they would just say, so we were not adjourned at all. But now the new law of 2003, which is actually a law by the Likud, Gideon Sa'ar law it's called, you have to have a majority of 7 in order to appoint a justice to the Supreme Court. And this is why you have to have compromise. Neither the judges, neither the coalition have the power to appoint without having some kind of compromise. And this is why I think in 15 years, 16 years, the court changed. You can see different views, different people, different sectors. And nevertheless, I totally agree that if there is a coalition that says we have to have more conservative people, not only conservative people, but to strengthen the conservative side of the Supreme Court, this is legitimate. This is why we have people from the coalition within this committee.
Are these just left-right issues? I mean, could somebody listening to this say, oh, you're a bunch of left-wingers and that's why you think this way?
Yeah, I'm sure that someone can say that.
Okay, but the reality?
And people say that. And it totally has connection to the reality, at least in the last 5 years, 10 years. It has a good correlation between whether you're leftist or whether you're from the right. But of course, this has nothing to do with the original, at least, right in Israel. When you read Begin's thoughts and Jabotinsky's thoughts, they were totally liberal. And Begin, of course, with his respect for the supremacy of the law or rule of law. So it doesn't necessarily has to have a right and left issues, but of course in the current situation people see it like that way, but you can see deviations from that. You can see Benny Begin in the last Knesset, and you can see Ruby Rivlin, which is, you cannot define him as a left. So you can see people from the right who still has respect for our checks and balances and for rule of law. We didn't say that this word, and I have to insist also that we're not only facing an attack against democracy or democratic values. We're facing an attack on the rule of law. Rule of law is respecting what the court says. Rule of law is that there is some kind of review of the court of what the government does. Rule of law says that everyone is equal before the law. When we talk about immunity, this is rule of law, and this cannot be disputed between left and right.
Okay, we really have run out of time, but this is a very technical question because I think it's important. You write a lot of legal opinions together with your colleagues at the Israel Democracy Institute. What happens with those legal opinions? You submit them to the Knesset. Do they have an impact? And that's going to be our last question because we want to know what role civil society can play in this process.
Yeah, I think that if we look 10 years now that I've been doing that, and the IDI didn't do it that before because the IDI in the past was just about some kind of academia and some papers that have policies in it, but not active to go every day to the Knesset and to the government. So we've been doing that, and I totally think that we had impact. We had impact on things that we succeeded on blocking totally, mostly in former Knesset, not in the last Knesset, but some things we had success, and I cannot really take credit for that. It's not just us, of course. It's all the community of NGOs and politicians and people who opposed. But we're, I think, important part of that. And sometimes we cannot block what we can minimize. For example, in the nation-state law, it's not the same that it was from the beginning.
You're saying it could have been worse?
A lot worse. In the beginning, there was a very important first paragraph that says that this nation law, some kind of a supremacy clause that says that this is the supreme basic law. It is, so there won't be any room for the court that says to interpret it as not contradicting the basic law of human dignity, for example. We had some success on also other issues within the nation-state law. Maybe if you heard about separation of villages according to ethnic origin, this was also taken out of the nation-state law. So we had successes, and we also had success to block the override clause in the former Knesset.
All right, Dr. Amir Fuchs, the head of the Defending Democratic Values project at the Israel Democracy Institute, as well as many other things. Thank you very much for joining us today.
Thank you too.
And also big thanks to Gizem Ozdemir, our sound engineer, and to Georgia Foscarini and Itai Shalom, our producers, as well as the Israel Democracy Institute for their generous support. Please do not forget to rate us on the Apple Podcast app. All you have to do is just open the app and writing us a review in the ratings and review section. You can also support us by going to our website, that's tlv1.fm/Tel Aviv Review, and subscribing onto our Patreon campaign. And even without subscribing, you can leave us your questions and comments that we will address on the air. Check out our archive. It has more than 500 interviews to keep you busy, entertained, and hopefully annoyed. If you like what we do here, you can also like us on Facebook. Our page is called the Tel Aviv Review Podcast, Ideas from Israel. And don't forget to follow Dalia and me on Twitter. Join us again next week for another edition of the Tel Aviv Review. And until then, from Dalia and from me, goodbye.